Hello everyone, I'm Anu, an engineer and a law graduate, and welcome to my channel where law meets logic and learning becomes easy. Welcome back to part 2 of our Family Law, One Hindu Law series. In this video, we'll be diving deeper into two powerful legal tools that play a crucial role in protecting our environment in India. What is the Hindu Marriage Act 1955? Explain why Hindu marriage is considered a sacrament and not a contract. What are the essential conditions for a valid Hindu marriage? Distinguish between void and voidable marriages. What are the grounds for divorce and judicial separation under Hindu law? Whether you're preparing for exams or just eager to understand how the law empowers citizens and authorities to fight pollution and safeguard nature, you're in the right place. Let's continue where we left off. Question 3. What is the Hindu Marriage Act 1955? Explain why Hindu marriage is considered a sacrament and not a contract. 1. Introduction to the Hindu Marriage Act 1955. The Hindu Marriage Act 1955 is one of the most significant legislations enacted by the Indian Parliament to govern the institution of marriage among Hindus. This act was introduced as part of a series of reforms aimed at codifying and modernizing Hindu personal laws, which until then had been mostly governed by diverse and often conflicting customary and religious practices. The act applies to persons who are Hindus by religion, which includes Buddhists, Jains, and Sikhs as well, unless their customs are specifically excluded by law. The main objective of the Act is to provide a clear legal framework regarding the solemnization of marriage, registration, where applicable, grounds for annulment, divorce, judicial separation, and maintenance between husband and wife. Before this Act, Hindu marriages were regulated by customs and religious rites that differed from one community to another. The need for a uniform law became evident to ensure social justice, gender equality, and to make the institution of marriage accessible and legally secure for all Hindus. 2. Key provisions of the Hindu Marriage Act 1955. Some important features of the Hindu Marriage Act 1955 are applicability. The Act applies to all Hindus, including Buddhists, Jains, and Sikhs, unless exempted. It also applies to any person who is not a Muslim, Christian, Parsi, or Jew by religion. Conditions for a valid Hindu marriage. Section 5. Neither party has a living spouse at the time of marriage, monogamy. The bridegroom has completed 21 years and the bride has completed 18 years of age. The parties are not within prohibited degrees of relationship, close relatives. The parties are capable of giving valid consent. The parties are not of unsound mind or suffering from diseases that make marriage undesirable. Solemnization of marriage. The Act recognizes marriages performed according to customary rites and ceremonies, or by registration under the Act. Void and voidable marriages. The Act defines what marriages are void, invalid from the start, and voidable can be annulled by a court. Grounds for divorce and judicial separation. The Act specifies conditions under which a marriage may be dissolved or separated legally, such as cruelty, desertion, impotency, adultery, or mental disorder. Maintenance and custody. Provisions are made for maintenance of wife, children, and custody matters post-divorce or separation. 3. Understanding Hindu marriage as a sacrament. To understand why Hindu marriage is regarded as a sacrament and not merely a contract, it is essential to look into the traditional Hindu worldview and religious teachings. What is a sacrament? A sacrament in Sanskrit, sanskar in Hinduism, is a sacred rite or religious ceremony that marks important stages in an individual's life, believed to purify the soul and bring one closer to the divine. Hindu marriage, viva, is one of the 16 sanskars prescribed in the ancient texts. Marriage in Hinduism is not just a legal relationship, it is a spiritual and religious union between two souls. It is considered eternal and indissoluble because it is believed to bind the couple for this life and many more to come. B. Marriage as a religious and social duty. Hindu scriptures such as the Manusmriti, Grihya Sutras, and the Vedas emphasize the religious significance of marriage. The union is seen as fulfilling dharma, righteous duty, artha, prosperity, and kama, pleasure, and most importantly, the continuation of progeny, family lineage. Marriage is not only for companionship but also for performing religious duties such as samskaras, sacraments, maintaining family traditions, and ensuring social stability. C. Characteristics of Hindu marriage as a sacrament. Irrevocability. Traditionally, Hindu marriage was regarded as permanent and indissoluble. The marriage bond, once created through sacred rituals, was not to be broken under any circumstances. Religious rites and ceremonies. The marriage involves a series of sacred rites such as Kanyadaan, giving away the bride, Saptapadi, taking 7 steps together around the sacred fire, and Havan, offering to fire. These rituals sanctify the marriage and bind the couple spiritually. Unity of souls. Hindu philosophy believes in the union of two souls, Atman, during marriage, signifying a bond that transcends the physical world. Community and family institution. Marriage is seen as a union not just between two individuals but two families, emphasizing collective social responsibility. 4. Hindu marriage is not a contract. A contract in legal terms is an agreement between two parties enforceable by law which involves mutual promises and can be dissolved if conditions are broken or by mutual consent. Hindu marriage, in contrast, has these distinguishing features, not based on mutual consent alone. Though consent is important, the marriage ceremony is deeply rooted in religious customs and involves families and communities. Indissolubility. Unlike contracts which are revocable, Hindu marriage is traditionally indissoluble and regarded as a lifelong commitment. No consideration or bargain. Contracts require consideration, something of value exchanged. Marriage is a religious sacrament and does not involve consideration. Spiritual and social dimensions. Hindu marriage fulfills spiritual goals and social obligations which contracts do not address. 5. Modern legal position, blend of tradition and reform. The Hindu Marriage Act, 1955, while upholding the sacramental nature of Hindu marriage, recognizes the realities of modern society. It introduced legal provisions for divorce and judicial separation, acknowledging that marriages may break down due to irreconcilable differences, cruelty, desertion, or other valid reasons. Thus, the Act strikes a balance. Sacramental view retained. Marriage is still fundamentally regarded as a sacred union, celebrated through religious ceremonies. Legal remedies provided. Divorce and separation are legally recognized to protect individual rights and welfare, a departure from the traditional notion of indissolubility. 6. Important judicial interpretations. In Raghunath vs. Raghunath, 1952, the Supreme Court affirmed that Hindu marriage is a sacrament, emphasizing the religious significance of marriage rites and their binding nature. However, courts have also upheld the validity of divorce under the Act, interpreting the law as a progressive reform to protect spouses' rights while respecting the sacredness of marriage. 7. Examples to illustrate the sacramental nature. Example 1. A Hindu couple gets married by performing the traditional Saptapadi and other Vedic rituals. According to the sacramental theory, this marriage is permanent and binding for life. Example 2. Despite the religious sanctity, if cruelty or desertion occurs, the aggrieved spouse can seek divorce under the Act, showing how the law adapts to protect individuals within this sacred institution. 8. Conclusion. The Hindu Marriage Act 1955 is a landmark legislation that codifies Hindu marriage law while respecting its religious roots. Hindu marriage is fundamentally a sacrament, a sacred spiritual union rooted in religious rites and social duties. It is not merely a contract, as it transcends legal formalities and is meant to be a lifelong bond. Yet, the Act recognizes the changing needs of society by introducing provisions for divorce and separation, ensuring the law serves justice, individual dignity, and social welfare. Understanding the sacramental nature of Hindu marriage alongside its legal framework helps appreciate the unique blend of tradition and modernity that governs Hindu matrimonial law in India today. Question 4. Explain the essentials of Hindu Marriage Act 1955 and what is void and voidable marriage. 1. Introduction. The Hindu Marriage Act 1955 provides a legal framework for the solemnization and validity of Hindu marriages in India. To understand the Act fully, it is important to know the essentials or conditions that make a Hindu marriage valid and recognize the difference between marriages that are void and those that are voidable under the law. 2. Essentials of a valid Hindu marriage under the Act, Section 5. For a Hindu marriage to be legally valid under the Hindu Marriage Act, certain conditions must be fulfilled. These are listed primarily in Section 5 of the Act and are as follows. A. Both parties must be Hindus. The Act applies only if both parties belong to the Hindu religion, including Buddhists, Jains, and Sikhs. If either party is a Muslim, Christian, Parsi, or Jew, this act does not apply. B. Neither party should have a living spouse at the time of marriage. Monogamy is mandatory under the Hindu Marriage Act. Neither the bride nor the groom should have a living spouse when they enter into marriage. If one party is already married, the subsequent marriage is illegal and void. See the minimum age requirements. The bridegroom must be at least 21 years old, and the bride must be at least 18 years old at the time of marriage. This ensures physical and mental maturity. D. Prohibited degrees of relationship. The couple must not be within certain prohibited degrees of relationship, meaning close blood relations are barred from marrying. These prohibited degrees are defined by custom and law to prevent incestuous relationships. E. Capacity to give valid consent. Both parties should be capable of giving free and valid consent. Consent obtained by force, fraud, or coercion is invalid. F. Mental capacity. Neither party should be of unsound mind or suffering from mental disorders that make them incapable of understanding the nature of marriage or perform marital obligations. G. No incurable disease or impotency. The groom should not be impotent, and neither party should suffer from any contagious venereal disease or any other condition making marriage undesirable. Ch. Marriage solemnized according to customary rites or ceremonies. The marriage must be solemnized according to the customary Hindu rites and ceremonies, such as the Saptapadi, 7 steps around the sacred fire, or any other prescribed ceremony. 3. Void and voidable marriages under the Hindu Marriage Act, 1955. The Act distinguishes between void marriages and voidable marriages with different legal consequences and remedies. Void marriage, Section 11. A marriage is void if it is invalid from the very beginning, i.e., it has no legal effect and is treated as if it never existed. Void marriages do not require a formal annulment because they are considered null and void automatically. Grounds for void marriage. If either party has a living spouse at the time of marriage, bigamy. If the parties are within prohibited degrees of relationship. If the marriage is solemnized between a sapinda, close blood relatives, unless customs allow it. Examples. A man marries a woman while his first wife is still alive. This marriage is void. Two siblings marrying each other. This is void as it violates prohibited degrees. Legal consequences of void marriages. The marriage is treated as null from the start. Neither party can claim rights as husband or wife. No maintenance or inheritance rights arise from such a marriage. Case law. In Kedarnath v. Nanku, 1962, the court held that a marriage is void if the parties are within prohibited degrees, even if they have solemnized it according to rites. B. Voidable marriage, Section 12. A voidable marriage is one that is valid and recognized until annulled by a decree of the court. It can be declared null only upon filing a petition within the specified time limit, usually 1 year from the marriage date. Until annulled, it remains valid. Grounds for voidable marriage. Non-consummation of marriage due to impotence of the respondent. Either party was underage at the time of marriage. Consent obtained by force or fraud. The respondent was pregnant by another man at the time of marriage. The respondent is suffering from a mental disorder, making cohabitation unsafe or unbearable. Examples. If a woman marries a man who was mentally unsound and could not understand the marriage contract, she can seek annulment on this ground. If a groom was below 21 years and the bride was below 18 at marriage, the marriage can be annulled if challenged within the time frame. Legal consequences of voidable marriages. The marriage is valid until annulled by a court. Upon annulment, the marriage is treated as never valid from the date of decree. Parties can claim restitution of conjugal rights or maintenance during the marriage. Case law. In Sarla Mudgal v. Union of India, 1995, the Supreme Court dealt with the validity of a voidable marriage and emphasized that the petition for annulment must be filed within the prescribed time. E4. Differences between void and voidable marriages. A void marriage is one that is considered invalid from the very beginning, as if the marriage never took place legally. Such a marriage has no legal effect, and there is no need for any formal court declaration to annul it. The law treats it as null right from the start. Examples of grounds that make a marriage void include if either party was already married, bigamy, or if the parties are within prohibited degrees of relationship, such as close blood relations, where marriage is not legally permitted. Since void marriages are never valid, the parties do not acquire the legal status of husband and wife, and no rights or obligations arise from such a union. Also, there is no entitlement to maintenance or inheritance based on a void marriage. In contrast, a voidable marriage is one that is valid and recognized by law unless and until it is annulled by a court decree. This means the marriage stands as legally valid until a party challenges it and obtains an annulment. Voidable marriages can only be declared null on specific grounds, such as impotence of one party, fraud or coercion in obtaining consent, one party being underage at the time of marriage, or if the respondent was pregnant by someone else when the marriage took place. The law allows a limited period, usually 1 year from the date of marriage, within which such challenges must be made. After this time, the marriage becomes absolutely valid. Until annulled, the parties in a voidable marriage have all the legal rights and duties of a married couple, including rights to maintenance and inheritance. In summary, while void marriages are legally invalid from the start and require no court action to declare them null, voidable marriages are valid until set aside by a court on certain specific grounds and must be challenged within a prescribed period. The distinction is important because void marriages do not confer any legal status or benefits, but voidable marriages do until they are annulled. 5. Practical examples. Void marriage. Ram is already married to Sita. Without divorcing her, he marries Geeta. This second marriage is void because bigamy is prohibited. Voidable marriage. Aisha married Ravi when she was 16, below legal age. Later, when Aisha turns 18, she decides to annul the marriage within 1 year of marriage due to underage consent. The marriage is voidable, not void. 6. Importance of recognizing void and voidable marriages. Protection of individual rights. The distinction ensures that marriages that violate basic legal principles like monogamy or prohibited relationships are not recognized at all, void. At the same time, it allows some flexibility where mistakes or defects can be corrected through annulment, voidable. Social and legal stability. This classification helps balance social stability by not invalidating every irregularity instantly, allowing chances to rectify errors, but also protecting the sanctity of marriage. 7. Conclusion. The Hindu Marriage Act 1955 clearly lays down the essential conditions for a valid Hindu marriage, emphasizing free consent, age requirements, monogamy, and lawful ceremonies. Understanding the difference between void and voidable marriages helps in comprehending the legal recognition and remedies available when a marriage is flawed. While void marriages are invalid from the start and cannot be legally enforced, voidable marriages remain valid until a court annuls them. These distinctions safeguard individual rights while respecting the sanctity and stability of the Hindu marital institution. Question 5. Discuss the grounds of divorce and judicial separation under Hindu law. 1. Introduction. Marriage is a sacred institution in Hindu law, intended to last for a lifetime. However, due to irreconcilable differences or serious breaches in marital duties, the law provides remedies such as divorce and judicial separation to address the breakdown of a marriage. These remedies ensure that individuals are not forced to live in unhappy or harmful marital relationships. The Hindu Marriage Act 1955 is the primary legislation governing marriage, divorce, and separation among Hindus. It specifies the grounds on which either spouse may seek dissolution or judicial separation of marriage. Divorce ends the marriage legally, while judicial separation allows spouses to live apart without ending the marriage. 2. Grounds for divorce under Hindu law, Section 13. Divorce is the formal legal termination of a marriage. The Hindu Marriage Act enumerates various grounds on which a spouse can file for divorce. These grounds are designed to protect the dignity and well being of both parties and to ensure that marriages can be dissolved when they become untenable. A. Adultery. Adultery refers to voluntary sexual intercourse by a married person with someone who is not their spouse. It is considered a grave breach of marital trust and loyalty. Adultery causes irreparable damage to the marriage, leading the aggrieved spouse to seek divorce. The proof of adultery requires clear and convincing evidence. Mere suspicion is not enough. The court often looks for corroborative evidence such as eyewitness accounts, letters, or other proof of illicit relations. B. Cruelty. Cruelty is one of the most frequently invoked grounds for divorce. It can be physical, like beating, assault, or mental, such as insulting, humiliating, or neglecting the spouse. Mental cruelty is often harder to prove, but can be equally harmful. The courts have held that cruelty means behavior that causes danger to life, limb, or health, or makes continued living together intolerable. It is subjective and depends on the facts and circumstances of each case. C. Desertion. Desertion means willful abandonment by one spouse without the consent of the other and without any lawful excuse. The desertion must be continuous for at least 2 years before filing for divorce. The deserted spouse is left in hardship, deprived of company, care, and support. Courts carefully examine whether desertion was voluntary and intentional. Daily conversion to another religion. If one spouse converts to a religion other than Hinduism and ceases to be Hindu, it can lead to divorce. This ground recognizes the importance of religious harmony in marriage. Mental disorder. If a spouse suffers from incurable insanity or mental illness, which affects the ability to live together or carry out marital duties, divorce can be granted. The mental disorder should be of such a nature that it makes cohabitation unsafe or unreasonable. F. Communicable venereal disease. Venereal diseases like syphilis or gonorrhea that are contagious and dangerous to the other spouse can justify divorce to protect health and safety. Renunciation of the world. If a spouse renounces worldly life by entering religious orders or vows of asceticism, the other spouse may seek divorce. This ground acknowledges the practical impossibility of continuing marital life under such circumstances. H. Presumption of death. If one spouse has not been heard of for 7 years or more and is presumed dead, the other spouse can file for divorce. B. No resumption of cohabitation after judicial separation. If a couple has been judicially separated for at least 1 year and have not resumed living together, either party may seek divorce on this ground. J. Mutual consent, Section 13b. Divorce by mutual consent is the most amicable and commonly used method today. Both parties must agree that the marriage has broken down irretrievably. They must have lived separately for at least 1 year before filing a joint petition. The court, after ensuring that reconciliation is not possible, may grant divorce without assigning blame. 3 grounds for judicial separation, Section 10. Judicial separation is a legal decree that allows spouses to live apart without dissolving the marriage. It is often sought as an alternative to divorce, especially when the parties do not wish to end the marriage permanently. The grounds for judicial separation mirror those for divorce, including adultery, cruelty, desertion, conversion, mental disorder, venereal disease, and renunciation. The important distinction is that judicial separation allows time for possible reconciliation. It gives spouses relief from cohabitation without ending the marriage bond. 4. Legal effects of divorce and judicial separation. A. Effects of divorce. When divorce is granted, the marital relationship ends legally and permanently. Both parties regain the right to remarry. Obligations such as mutual support and cohabitation cease. Property rights and maintenance claims may be adjusted through court orders. Custody of children is determined independently of the marriage status. Divorce also has social and emotional implications. Courts encourage spouses to consider the consequences before seeking divorce. B. Effects of judicial separation. With judicial separation, the spouses live apart but remain legally married. Neither spouse can remarry during the separation period. Maintenance claims can be made for support. The separation period allows reflection and possible reconciliation. After a period of separation, judicial separation may be converted into divorce. Judicial separation provides relief to those unwilling to divorce but needing a legal framework for living apart. Five examples and case laws. Sarla Mudgal vs. Union of India, 1995. The Supreme Court emphasized that divorce should be granted only after careful consideration, recognizing the sanctity of marriage. The court also ruled on issues relating to polygamy and conversion for divorce. Ramesh Chander Kaushal versus Veena Kaushal, 2006. The Supreme Court elaborated on the scope of cruelty, recognizing mental cruelty as valid grounds for divorce even without physical abuse. Himanshu Narendrabhai Mehta Viran State of Gujarat, 2007. This case clarified that desertion requires voluntary and intentional abandonment, not mere absence. V. Bhagat v. D. Bhagat, 1994. The Supreme Court ruled on cruelty in marriage, stating that the behavior must cause danger to life or health or make living together intolerable. 6. Conclusion. Divorce and judicial separation are crucial legal remedies under Hindu law to address the breakdown of marital relationships. While divorce ends the marriage legally, judicial separation allows spouses to live apart without dissolving the marriage. Both require specific grounds such as adultery, cruelty, desertion, and others, ensuring that the law balances individual rights with the sanctity of marriage. Understanding these grounds helps protect the interests of both spouses and promotes fairness and justice in matrimonial disputes. Do like and subscribe for more videos, and don't forget to check out the other videos on this channel as well. In the next part 3, we will continue with the remaining important topics. What is adoption under Hindu law? Explain the requirements and legal effects under the Hindu Adoption and Maintenance Act, 1956. Define maintenance under Hindu law. Discuss its nature and extent under Old and Modern Hindu law. What is the Hindu Succession Act, 1956? Explain its scope, main features, and the general rules of succession for male and female Hindus dying intestate. Please like, share, and subscribe. Thank you for watching.